If I can find my browser. There we are. All right. Welcome to the August 18th, 2026 meeting of the Planning Board. First, we'll take a roll call to introduce board members and staff. Phil Giordano,
I am here.
Tim Haladina,
Here.
Mike Derderian.
Here.
I'm Ellen Rawlings. I'm also here. We are also joined by Jess Cole, our recording secretary, Nora Loughnane, our director of community and economic development. Is Ariel or Ariel? Which do you prefer?
Sounds the same to me, but Ariel is fine.
Ariel. Okay, Ariel Sasser, our brand new town planner, and Charlotte Lynch from Westwood Media Center. Sorry, back to my remarks. This meeting is recorded by Westwood Media Center and broadcast live on local cable television Comcast Channel 6 and Verizon Channel 42. Meetings are also live on the Westwood Media Center's YouTube channel. If you're interested in joining the meeting via Zoom, you can find the login directions in the Planning Board meeting notice that is posted to the calendar section of the town's webpage at https://www.townhall.westwood.ma.us/. We will begin the meeting with only the board members and staff unmuted and on video. As the chair recognizes individuals to speak, we will unmute them. Board members may choose to mute themselves when they are not speaking in order to minimize background noise. For applications, the chair will first invite the applicant to address the board and give a presentation summarizing what is being requested. Board members received the application materials prior to the meeting and will have reviewed them. Board members may ask questions during and following the presentation. Staff and outside experts will provide comments to the board. If the issue includes a public hearing, the board will then proceed to the public comment portion of the public hearing and will restate the instructions. In this remote meeting format, residents and guests may participate in several ways. Attendees should raise their hand and wait to be unmuted and recognized to speak over the Zoom meeting application or from a telephone dial-up. We will be able to hear you but not see you. Additionally, comments may be submitted by email or regular mail prior to the meeting. When we come to that part of the meeting, I will remind everyone of the process. Following the public comment portion, the board will deliberate and make a decision or continue the hearing to a specific future date. All remote meetings require that votes be taken by roll call. When a motion and second has been made, the chair will ask if there is any further discussion before proceeding to a roll call vote and will then restate the results of the vote. All right. Nora, do we have any changes to the agenda this evening?
We do not.
Okay. In that case, the first agenda item is a public hearing for consideration of limited environmental impact and design review approval for replacement of Scoreboard for Xaverian Brothers. As this is a brand new hearing, I will read a short portion of the hearing notice to open the hearing. The Westwood Planning Board will hold a remote public hearing on Tuesday, August 18th, 2026 at 7 p.m. via Zoom regarding an application filed by Xaverian Brothers School for consideration of a limited environmental impact and design review approval pursuant to Section 7.2 of the Westwood zoning bylaw for the purposes of installing a new scoreboard adjacent to the football field at Xaverian Brothers School, 800 Clapboardtree Street, Westwood, Mass. 02090. In accordance with application PB-26-23. The property is in the Single Residence E, SRE, zoning district and within the Access Approval Overlay District, AAOD. Land affected is Assessor's Map 23, Lot 003. Property owner is Xaverian Brothers High School. All right. Oh, and it looks like we have a few folks from the Xaverian team. I see Dr. Conca. Nice to see you again.
Hello, welcome. Good to see everybody.
Do you have have we promoted everybody that you need on your team for the presentation to panel?
We have. So Patrick Hayes is joining us as well. I see that he's on the screen. So I think it's Patrick and I tonight. We're all set.
Wonderful. Then I'm happy to hand the floor over to you to present your project.
Certainly. So first things first, just want to thank everybody for obviously being here tonight and for your work in the town, and just a special congratulations to Ariel on her appointment. Also, just very quickly want to thank Nora, Mike Perkins, and the town staff who've been very helpful as we've been preparing for this presentation. Essentially, myself, I think I know pretty much everybody on the call here, but for those folks that maybe I haven't yet met, Jake Conca, I serve as the head of school at Xaverian. I've been there since 2019 as the head of school. Principal before that. I was a dean of students before that and a graduate of the school. I'm pretty sure folks know, but Xaverian, we serve boys in grades 7 through 12 here in the town. Very fortunate that we have close to 40 Westwood families who are served by our school as well. So we consider ourselves an asset to the community, and certainly appreciate all that the community does for us. Joining me tonight is Patrick Hayes. So Patrick is a member of Beacon Architectural Associates. Pat and his firm have worked with us on several different projects. I think some of the planning board members will recognize Pat from some of our prior presentations. But essentially, we come before you tonight, and Patrick will walk you through the details with an opportunity to replace our existing scoreboard. So just for reference, the current scoreboard that's on the varsity field, we were talking with our resident historians at the school in the last couple of days. We believe it's anywhere from 25 to 25 plus years old. We've been very fortunate in that we've had some folks come forward to offer to assist us in replacing the scoreboard. So with that, we were able to select a scoreboard. Beacon has helped us obviously with the planning. And we're hoping that we can gain approval tonight to install the new scoreboard in preparation for the beginning of the fall athletic season. So that's a quick introduction for Xaverian, quick introduction to our project. I think at this point, I'll turn it over to Pat, who can walk everyone through some of the specifics. And then obviously we're happy to answer any questions that folks may have. So Pat, I'll turn it over to you.
Thanks, Jake. I'm just trying to figure out how to share my screen. There's a plethora of screens up in front of me here.
It looks like sharing privileges are turned on.
Yes.
The first screen you had, Pat, showed one of the diagrams. So I think we're looking at maybe your inbox now.
Okay.
We're looking at your emails.
That's
There.
it right there.
That's the one we want. My apologies. Thank you for bearing with me. So as Dr. Conker said, Jake said, I'm Pat Hayes. I'm with Beacon Architectural Associates. And so we've been assisting in the planning process here. Up on screen now is the presentation that we had submitted with our application. And you can see this is the Xaverian Brothers campus. So along the bottom of the page, we have Clapboardtree Street here, baseball field, and then the football field. This area over here, that is the building, the school itself. And as you can see here, this is the area of our discussion tonight. This is where we're looking to install the new scoreboard. The existing scoreboard is right in this location right here. And just generally, as you can see, this scoreboard is slightly askew from the existing location. And the reason for that is just better sighting. When you think about the home team and being able to see the scoreboard, we also have the visitors bleachers over on this area. And so they're still able to see the scoreboard as well. But this was, as we looked at where to site the scoreboard in relation to the field and the patrons and the spectators, this is really the best place for to maximize sight lines and visibility. These images here are just showing us the existing conditions. So this photograph here, if you're driving up Clapboardtree Street, just before you get to the first drive that takes you into the campus, you can see this is the area that we're going to be looking at. These trees here, you can see the bleachers in the distance. The football field is there. A little bit further on, as you're right in that drive itself, this is just same sort of angle, but a little bit closer. This is the existing photo down here. This is the existing scoreboard that Jake had mentioned earlier. As you can see, there is a little bit of signage here. And so that is another part of our puzzle tonight to talk about is the backside of our new scoreboard being a sign that is very visible. This image right here is actually on the field and looking in the general direction of where the new scoreboard is going to be. In the distance area, you can see the existing scoreboard, but this is the general location of where the new scoreboard will be. And then from the other angle, if you're out in the field, if you're in the bleachers looking out towards where the new scoreboard is located, you see these two trees here. The new scoreboard is going to be located right in front of those trees there. As you see, this is sort of an aerial view of the entire site. This blue arrow here, that is where the scoreboard is going to be. The two vantage points that we were talking about were sort of right along here, from this vantage point looking, and then from this vantage point over here. This vantage point here is from, in this general area right behind the end zone. You can see the existing scoreboard. And then again, this is where we're proposing to put the new scoreboard. And then from the field itself, existing scoreboard here. And then, this is where we're proposing to put the new scoreboard. And so, again, now this is taking those same photos, those same existing photos, and superimposing within those photos the proposed scoreboard. So, as you can see here, as you're looking at these, you can see the outline of the scoreboard sort of through the trees, through the foliage, if you will. And then from quite a different angle, here is the existing scoreboard. And again, you can see a portion of the scoreboard peeking out beyond the tree there. And then, during the season when the leaves are gone, this is the actual full scoreboard that you see full view when there's no foliage. I will say this, you see the size of these trees compared to the size here. These trees are actually a little bit smaller. This photo was taken a couple of years back, so I think it's maybe from 2021. So there's 5 years of additional growth on the trees that show the leaves here. So, and then going back again and looking from the field view, here is the existing scoreboard, and then this is the proposed scoreboard. And then just from a sighting standpoint, we have some existing trees. So during the construction, the intent is that, we're going to be protecting the trees and the roots. Overall disturbance of the land is sort of less than 1,000 square feet or so. They'll have to dig the footings and then, install the signage. This is an image of the actual scoreboard itself. And so if you look on the bottom here, only one of these banners is actually part of the scoreboard, but I wanted to share the color version. And so what we have is overall, there's 7 feet at the bottom here that makes up the banner, Home of the Hawks, and then the scoreboard itself. And then there's a new digital display for the scoreboard. And this is 17 feet tall, 32 feet wide. And then there's a decorative truss that goes across the top with the branding X across the top. So overall, the overall height of the sort of solid portion, if you will, is about 24 feet high, and it sits about 8 feet off the ground. And then there's another 5 feet or so up here. So when you look at the total height, you're looking at a scoreboard that sits off the ground. It's about 37 feet tall, give or take. And overall, it's about 32 feet wide. From an area standpoint, I did see Mike Perkins had shared some comments of our submittal on the portal. And he did note that the proposed scoreboard is, all of 5 times the size of the original. And, admittedly, it is large. But I think when you consider where athletics is going these days and what the school is trying to do for the student athletes, this is definitely something that's keeping in times and definitely well needed to replace the 25-year-old scoreboard that is there. So with that, I don't know if there's any other questions or.
Pat, could I just maybe add one other additional comment that I think we had talked about? This is We're also viewing this as, in addition to being a scoreboard that works for all of the sports that take place on the field, we're also looking at it as an educational tool. I think, as Pat had mentioned in his presentation, the scoreboard is 100% digital. And one of the things that we're looking to do, more and more of our students have expressed an interest in sports management, game day preparation, game day execution. So this scoreboard also comes with it a specific curriculum that our intention is to train up our students so that they can get experience in working with something like this, and hopefully not only experience the fulfillment that comes with learning the skill sets associated with a scoreboard, but hopefully take some of those skills onto their post-Xaverian plans and utilize them perhaps in a college setting. That's something that we're seeing more and more of our students look to pursue when they get to the college level. So there's also a teaching element to this as well.
Thank you. All right. Are there any notes or comments from our staff before I open it up to board comments? You're muted, Nora. Sorry.
You? Thanks. I'll just read to you Mike Perkins' comment in the portal. Due to the size and video board aspect of the scoreboard, along with the number of signs already located on the property, the large logo facing Clapboardtree Street is considered a sign. This would normally require a special permit from the Zoning Board of Appeals. However, an exempt use such as Xaverian Brothers cannot be made to seek such an approval. This limited EIDR is the mechanism for approving the scoreboard. The proposed scoreboard is approximately 928 square feet in area, which is nearly 5 times the size of the existing scoreboard and structure. From the public way and adjacent properties, it appears that the video board and lighting associated with the scoreboard will not be visible, with only the X logo facing away from the athletic field and track. Because of this, there would not be a discernible impact to the neighborhood, and the scoreboard's location is adjacent to the existing, limiting an increase in adverse conditions. If the scoreboard is approved, as shown on the provided plans, both building and electrical permits will be required for this installation.
Thank you. Any additional staff comments aside from our building commissioner at this time?
I think that is the only significant comment I saw. Most other department staff members just had no comment on the proposal or commented that it's acceptable.
Thank you. All right. Then at this time, I'll open up the floor to planning board member questions, comments. Phil.
Yeah, just a quick question. Was there consideration to the other end of the football field? Partly because, and I say this because of the size issue, it struck me, having been there and having had a son graduate from Xaverian, that the far end of the field away from the Clapboardtree side seemingly was a better location, and maybe you can just touch upon that.
Yes, that's a great question. We did analyze placing the scoreboard on the backside. We originally were hoping to place it here. I think if the board remembers our presentation from earlier in the year, the school is involved in a large addition renovation project right now.
Right.
And part of that future renovation involves an expansion of the field house in this general direction, this general area rather, of the site. And so when we analyzed our sight lines and looked at the sight line studies, because of this building here, the sight lines for folks in the stands, they did not have full view of the scoreboard. And it wasn't until the scoreboard came, almost all the way around to this portion here. And then, of course, when you come that far around, the folks in the visitor stands don't have the right angle. And so
why do you have to go that far over to, because that's what I was actually thinking, closer to the visitor side, because I remember about the discussion about the additions and the construction, and it's coming up. So I was automatically assuming that corner was not going to be accessible or available, but but it struck me is that the opposite side, closer to the baseball field side, but not necessarily not all the way there, but I'm saying maybe angled such that the visitors and the home stands could see it.
Yeah, so if you were to consider, sort of this position
Right.
totally opposite,
Right.
that's sort of the minimum area you would need to, still maintain decent sight lines in the direction because of the angle of the scoreboard. But again, there's I don't have the sightline studies that I can share with you, but there's a portion, it's not until you actually get over to this area here before the folks that are in this area of the stands totally clear the sight lines, with the building. When you're sitting there and you're looking across, the entire scoreboard ends up being in a position where the angle is a little too oblique for the folks in the visitor stands to actually see the scoreboard.
Okay. I was assuming because of the increase in size, it would also have greater visibility that the visitor side would get the sight lines. But you're saying you considered that, but it's simply not necessarily feasible for both sides.
Yes, we did consider that, and the angles just didn't work out the way we had hoped.
Pat,
And it actually,
Pat, if I could just, if I remember correctly, Phil, I know the part of the field that you're referring to there is by the roadway that goes to the back. There's also the track in that area is raised, so there's a significant downward slope. Pat, correct me if I'm wrong, but I think the manufacturer and installer were concerned with our ability to successfully put footings there for the scoreboard, and I think that, in addition to the sight lines, prompted us to look at the other side.
I remember that now. You're right. Okay, that actually makes a better explanation for me because I have been there many times, and that makes sense.
Yeah.
Okay, that was my only question. I'm good.
To your point, Phil, ideally, we had actually hoped to put it down that end, but when we analyzed, Pat, I think we analyzed a half dozen different variations. It was we ran into sight lines or we ran into footing issues. Was my recollection.
Okay.
Yeah, the focus of our study was the sight lines, but yeah, you're absolutely right, Jake, and I had forgotten about the slope and the structural aspects. The footing for this structure is substantial. It's about 15 feet wide by, I want to say 15 by 28, give or take. So it's a very large footing, for the sign.
And like I say, I've been there, so I do remember the slope. I understand the issue. So okay, thank you.
Thanks, Phil. Tim.
Thanks, Ellen. I had a question, probably more for staff. Are there any minimum or brightness requirement minimums? I'm trying to think about other instances in town with signs or situations like this where the video I think is going to add quite a bit of brightness to, I think you read in Mike's comment that you wouldn't be able to see the brightness from the other side. I just was curious if there are any standards for that that exist. I didn't see any mention of anything in the materials and prep, so just a question for our staff.
So our zoning bylaw doesn't have any specific requirements related to video screens, but we do have requirements for any type of exterior lighting. And those limit light trespass beyond the edges of the property. So as long as the light is not at a significant volume, the lumens are not too high at the edges of the property, this would be permitted.
Got it. And that's what Mike was referring to as far as not visible. Okay. Thank you, Nora. And then my other question real quick was, is this change anything at all with respect to the PA system, sound and speakers? Living relatively close, I know it is relatively loud at times. So I just was curious if this changes the dynamic at all there in either direction, or if there's no speakers here, then it's a moot question.
Tim, no speakers at all on this.
Great, thanks.
Thank you. Any other board member questions, comments at this time?
No.
I was just going to say that I think Mike Perkins' comment is significant in terms of, the the impact to the roadway in the periphery. So I don't see any issues, and I think this will be a great addition to the school.
Thank you. Yes, I was happy to see that note from Mike, because that would have been really my only concern is there going to be some sort of issue with excess light, either, causing a problem for people driving or for butters or whatever, but it sounds like Mike put eyes on that, and his assessment is that that will not be a problem. So, I feel okay about that. All right, it sounds like there are no additional board member comments or questions at this time. So as this is a public hearing, I will open up the floor to public comment. If there's anyone in attendance who would like to ask a question or make a comment on this project, please either raise your hand, and we can either promote you to panelists so that you can speak directly, or please feel free to enter your question or comment into the Q&A portion of the Zoom application. We would just need your full name and address for the record to be able to address your question. You can give that a moment. I'm not seeing any hands.
No hands and no typing in the Q&A.
All right, then if there's no further discussion amongst staff, applicant, and or board members, and I do not see any public comment, I would entertain a motion if anyone's interested in making one.
Okay, just 1 minute and I will share my screen. I think, Patrick, if you could stop sharing, then I'll be able to share the motion. Thank you.
I move that the planning board grant limited environmental impact and design, there we go, review LEIDR approval for the proposed new scoreboard at Xaverian Brothers School, as described in the application, therefore submitted to the planning board and filed in the office of the town clerk on July 21, 2026, subject to the following conditions. 1, except as modified by the conditions and finding hereof, the project shall comply with the project plans in all respects, and the applicant shall pursue completion of the project with reasonable diligence and continuity. 2, if the project or any condition imposed in this decision requires any other permit, license, or other approval from any town of Westwood board, commission, or agency, or other Commonwealth or federal regulatory agency, the applicant shall make an appropriate application for the same and shall obtain all required approvals prior to the start of any work. If any condition of such permit, license, or other approval from any other board, committee, or agency is inconsistent with this decision, the applicant shall make application to the planning board for an amendment of this decision, and the planning board shall consider such application in accordance with the requirements of MGL Chapter 40A, Section 9, and all applicable planning board rules and regulations. Any proposed alterations, modifications, deletions, or changes to the decision shall be requested in writing to the town planner and building commissioner prior to implementation. 3. A, proposed alterations which are considered de minimis by the building commissioner may be accepted as a note to the file. B, proposed alterations which are considered minor by the building commissioner shall require the filing of modification application of said approval for review by the planning board at a publicly posted planning board meeting. C, proposed alterations which are determined to be major by the building commissioner or by the planning board shall be considered by the planning board as a formal amendment to the approval and will require a new public hearing for the planning board.
This next,
including
number 4 is
but
highlighted.
are we
If
including
I could just
4?
interrupt. This is highlighted because I added it. The board had not seen that in their drafts.
So we're including 4, correct?
Unless you want to remove it after you make the motion.
Okay. Well, I just want to make sure that I'm on the right page. 4,
You are.
in the event the new scoreboard results in a demonstrated trespass onto abutting properties, the applicant shall make reasonable efforts to mitigate the light trespass onto abutting properties. 5, This decision shall lapse if a substantial use thereof or construction thereunder has not begun, except for good cause, within 2 years following the grant thereof. Planning board may extend such approval for good cause upon the written request of the applicant. A copy of this decision, 6, a copy of this decision and the project plans shall be kept on the project site at all times during construction. 7, all project-related construction activities shall comply with the timeframes set forth in the town's general bylaws, Chapter 292 for noise and construction, which allows such work Monday through Saturday between the hours of 7 a.m. and 7 p.m. and Sunday between the hours of 12 p.m. and 7 p.m. 8, at the conclusion of construction and prior to the issuance of a certificate of occupancy, the applicant shall submit as-built plans delivered in a format approved by the GSI manager for compatibility with the Town of Westwood GIS database.
Second.
I have a motion and a second, and I actually do have a quick question before I ask for further discussion. Thank you. I appreciate condition number 4. I think that's appropriate.
Yes.
Just in case, if it turns out that, our estimations of the impacts are not quite what we think they are, I think that's appropriate. My question is related to that. If it turns out there is some light spillage, say onto Clapboardtree, or it creates a hazard for drivers, do we need to condition that, or is that something that would just be a safety issue that would have to be dealt with anyway?
So that, yes, it would have to be dealt with if it was a safety issue that would be outside of zoning. However, the positioning of the scoreboard facing towards the field and away from the road substantially decreases the likelihood of any of the light from the scoreboard extending to the street.
Right. That's my sense as well. I'm just like, as a contingency, it sounds like I was just curious if we had to condition. Obviously, I'm certain that the folks at Xaverian, if it were causing a problem for drivers, it wouldn't even be a conversation. They deal with it. But I wasn't sure if we needed to condition it or if that would be handled by like I don't know, whoever handles safety issues like that. So we don't have to do anything for that remote possibility.
You do not.
Okay.
Okay. So for amended, in the event the new scoreboard results in demonstrated light trespass onto abutting properties, the applicant shall make reasonable efforts to mitigate the light trespass onto the abutting properties. We need a second for the amendment.
Second.
Thank you. I have an amended motion and a second. Is there any further discussion? I'm not seeing any board members raising their hands. Then I will take roll call. Phil.
Aye.
Tim.
Aye.
Mike.
Aye.
I vote aye as well. That motion carries. I think we have one more motion on this item.
Yes.
I move the planning board close the public hearing for consideration of the limited environmental impact and design review, LEIDR, approval for the proposed new scoreboard at Xaverian Brothers School as described in the application therefore, submitted to the planning board and filed in the office of the town clerk on July 21, 2026.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Tim.
Aye.
Mike.
Aye.
Aye.
I vote aye as well. That motion also carries. Public hearing is closed. And thank you. Good luck with the scoreboard installation.
Good luck this season.
Thank you
Thank
all
you.
for your support, but most especially your work for the town. We appreciate you. Thank you,
Thank you.
everybody.
Thank you, Dr. Conklin.
Good
All right.
night.
Good night now.
Good night.
All right, then our second agenda item is a continuation of a public hearing for consideration of environmental impact and design review, EIDR, approval for a change of use and exterior and site alterations for the proposed Walmart Spark Store and special permit for reduction of required parking at 21 to 25 Southwest Park, PB26, PB-26-21 and PB-26-22. This is continued from our July 28th, 2026 meeting.
And we have Bill Lucas here to represent Walmart.
Hi, good evening. Bill Lucas with Bowler.
Welcome.
Welcome. Good evening to everyone. I wasn't sure at one point in time we may need to promote Greg Keys of PB2 Architecture. as part of this conversation. But for now, I'll get started, and we'll cross that bridge when we get to it. So first off, uh, Bill Lucas with Bowler. We represent Walmart as their civil engineering consultant. At your last planning board meeting, we were represented by Molly Obendorf, who gave a full presentation on the project. I was also part of that meeting, listening in as an attendee. So I have full background on this project, and I have been in lockstep with Molly along the way. Unfortunately, she decided to take some time off this week, so hopefully she's enjoying that, and put me in the hot seat for this evening. So as I noted, at the last planning board hearing, we received feedback from the board members and have made some adjustments to our drawings. In particular, one major item was an inclusion of a landscape plan. We heard that loud and clear. All of our plans have been updated based on the comments from the board and the beta letter that we had received. Since that time, we had made a resubmission to beta on August 7th, and they were promptly responsive to then provide us with a new letter as of August 17th. That letter, based on our review, looked fairly clean, or were clean. Hopefully you see it the same way I do. And at this juncture, we believe we could be in a position to ask for an approval for this project for the special permit and a handful of waivers that we had requested at the previous hearing. With that said, I'd like to open it back up to the board to see if there's any further questions or concerns on your end that we can go ahead and address.
Thank you very much. Any comments from staff?
There are no new comments from staff. We did review the proposed landscape plan. Bill, did you want to share that plan?
I absolutely can.
Okay. The new plan is, you remember we had noted that there were 3 or 4 trees that had been removed over time, as well as some perimeter plantings around the edges of the front of the building. And so the landscape plans were revised to include planting of new trees and new shrubs.
Great. Hopefully everybody can see this on screen. The existing building is shown in gray. You have Southwest Park at the top of your screen, and then the parking around the site itself. As I move into the front of the building, on the far left, there is an existing tree that we will show to remain and be protected as part of any of the construction efforts. And then we have gone ahead and proposed 4 additional trees along that same frontage. The second part of the landscaping plan was to then augment or rework the entire front of the building itself. It was clearly, you know, overgrown or no growth in certain areas along that frontage. So we will go ahead and replant that with a variety of perennials and shrubs and flowers of that nature to enhance the entire look along the front of the building. No other landscaping was proposed on the site itself, as is primarily impervious coverage along the rear and sides of the building. But another item that we did introduce was a bike rack, which will be closely located to the proposed ramp near the main door of the building. I think that gives a quick overview of the changes.
Thank you.
Then the other item that is in the board's packet is a final report from Steve Lee of Beta that discusses the project. And I believe there was one additional comment that was added today on Steve's report regarding the placement of a bollard at the end of the handicapped ramp.
I did not see that comment. regarding the bollard, but I would assume that we would be amenable to its placement. I would have to see the final location, but I believe that is probably for protection purposes of maybe the bike rack or just any vehicles approaching the ramp. And so, additional safety seems feasible to me.
Thank you. Any further staff comments?
I do not have any further comments. Ariel, did you have any other comments on this?
No, none except the one that you said. That additional comment from the peer review letter. So I'm all set.
Thank you. I typically ask my colleagues for their comments first, but as we were just on the landscaping, the only comments I had was on a couple of the species. So if nobody objects, I'll just happily give you that feedback now and then open the floor to my colleagues. As far as Massachusetts native go, the pin oak is not a terrible choice, but a red or a white, a northern red or scarlet or a white oak would be a better choice. It's really a truly Eastern Massachusetts native. The rhododendron species that you specified, I think it's not a Massachusetts one. I think by the name, it might be an Asian species. There are rhododendron species that are Massachusetts native, and they are a nice choice. So if you could choose one that actually was a Massachusetts native, that would be wonderful. And then the catmint species and the coneflower species. I'm not sure that there is a native species of coneflower. I feel like we bumped up against this before. But that particular species of catmint is not a mass native. So again, if you could choose a species of catmint, a lovely plant, it's nice ground cover. One that is a Massachusetts native. I'm not sure where that one originates from, but I could not find any evidence that it was a Massachusetts native. So just those four species, particularly the rhododendron, the catmint, and the coneflower, because those are not native at all, not necessarily even native to this country. The pin oak, it's not my first choice, but it's not a totally inappropriate choice. So if you can't find a red or a white, the pin oak isn't terrible, but a red or a white oak would be better. So those were my only comments. So now I will happily open up the floor to my colleagues. If anyone has questions. I'm not seeing any hands from my colleagues.
I would just say that I was mostly very pleased with the reaction, the response to our prior meeting. So I thought it was responsive. So it was nice.
Thank you, Phil. Agreed.
And to that end, I can go back to our landscape architect and make adjustments to provide additional or better native species for each of those that you've recommended.
Thank you. And from my perspective, that's not something that would impede any work we do tonight. That's something we could cover with a condition and an approval
Perfect.
if we go that way. With just submitting that plan through the town planner and staff for final approval. I'm fine with that unless anyone else has a differing opinion. And thank you. I appreciate that. Any other board member questions, comments? All right, then I will open the floor to public comment. If anyone would like to ask a question or make a comment on this project, please raise your hand or use the Q&A section in the Zoom application. We would just need your full name and address for the record. We can give that a moment. I'm not seeing any hands, nor am I seeing anything in the Q&A. I'm seeing everyone affirming my perception there. So with that, if there is no further discussion, I would entertain a motion if someone is ready to make one.
Okay, just give me 1 minute. I'm just updating the comments.
Thank you.
Mike, you're up.
I can do this in record time.
I don't know if speed is part of the process.
I move that the planning board grant a special permit for reduction of required parking spaces and consolidated environmental impact and design review EIDR approval for the proposed Walmart Spark store at 21 to 25 Southwest Park as described in the applications, therefore submitted to the planning board and filed in the office of the town clerk on June 26, 2026 with the following conditions. 1. Except as modified by the conditions and finding hereof, the project shall comply with the project plans and with the conditions of all prior decisions for the property in all respects, and the applicant shall pursue completion of the project with reasonable diligence and continuity. 2. If the project or any condition imposed in this decision requires any other permit, license, or other approval from any town of Westwood board, commission, or agency, or other Commonwealth or federal regulatory agency, the applicant shall make an appropriate application for the same and shall obtain all required approvals prior to the start of any work. If any conditions of such permit, license, or other approval from any other board, committee, or agency is inconsistent with this decision, the applicant shall make application to the planning board for an amendment of this decision, and the planning board shall consider such application in accordance with the requirements of MGL Chapter 48, Section 9, and all applicable planning board rules and regulations. 3. Any proposed alterations, modifications, deletions, or changes to the decision shall be requested in writing to the town planner and building commissioner prior to implementation. A. Proposed alterations which are considered de minimis by the building commissioner may be accepted as a note to the file. B. Proposed alterations which are considered minor by the building commissioner shall require the filing of a modification application of said approval for review by the planning board at a publicly posted planning board meeting. C. Proposed alterations which are determined to be major by the building commissioner or by the planning board shall be considered by the planning board as a formal amendment to the approval and will require a new public hearing before the planning board. 4. The applicant shall submit a revised site plan addressing concerns raised by Steve Lee of Beta Group, Inc. in his peer review memo dated August 18, 2026 for review and approval by the town planner prior to the start of construction. 5. The applicant shall submit a physical masonry mock-up and a physical glass door sample, both of which shall demonstrate an effective match to the existing conditions for review and approval by the town planner prior to the start of construction. 6. All project-related construction activities shall comply with the timeframe set forth in the town's general bylaws, Chapter 292 for noisy construction, which allows such work Monday through Saturday between the hours of 7 a.m. and 7 p.m. and Sunday between the hours of 12 p.m. and 7 p.m. 7. All landscaping shall be Eastern Massachusetts native species and shall be installed at the earliest possible date, but only during the fall growing season, running from September 15 through November 15. A revised landscape plan confirming all native species shall be submitted for review and approval by the town planner prior to installation. Any plantings that do not survive shall be replaced in kind in perpetuity at the property owner's expense. 8. A copy of this decision and the project plans shall be kept on the project site at all times during construction. 9. The decision shall lapse if a substantial use thereof or construction thereunder has not begun, except for good cause, within 2 weeks following the grant, 2 years following the grant thereof. The planning board may extend such approval for good cause upon the written request of the applicant.
I second and exclude the 2 weeks.
2 years.
I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Mike?
Aye.
Phil?
Aye.
Tim?
Aye.
I vote aye as well. That motion carries.
I move that the planning board close the public hearing for the requested special permit and environmental impact and design review, LEIDR approval for the proposed Walmart Spark store at 21 to 25 Southwest Park as described in the applications, therefore submitted to the planning board and filed in the office of the town clerk on June 26, 2026. And it is an EIDR approval.
Thank you.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Phil?
Aye.
Tim?
Aye.
Mike?
Aye.
I vote aye as well. That motion carries and the public hearing is closed. Thank you very much and good luck with the project.
Thank you, and thank you to all the staff for your continued efforts to assist us on this.
Thank you.
Have a great night.
You too. All right, our next item is consideration of proposed modifications to environmental impact and design review EIDR approval for a retroactive change of use to a professional services establishment, parking modifications, roof replacement, and other facade alterations at 378 Washington Street, and this is PB-25-42. All right. Oh, okay. It looks like we have the applicant here. Welcome back. Hi. Sorry, it looked like you were about to speak.
Yeah, no problem. I was just going to say good evening. I'm Bill Kring. I'm the owner of 378 Washington Street. I'm the son of Attorney Kring, who's representing 378 Washington Street in this matter. He was discharged from the hospital a little over a week ago, yet again. And I'm appearing tonight solely to basically object to this being on the agenda and to preserve our rights. I'm not appearing to participate on the merits. We received no formal notice that we were going to be on the hearing tonight, except for an internal town email that was forwarded to us, I guess, on Saturday. And my father became aware of it today because he's largely bedridden right now. And he asked me to join. Other than receiving that internal town communication, we didn't receive any notice, any letter or anything to that sense. But that makes it a bit, this proceeding in particular, a bit concerning. The planting requirement that was contemplated for April 15th to June 15th, before that had even arrived, we had been communicating with the town, seeking guidance. In particular, we were having issues with the species of plants. We had contacted 3 nurseries. And we were not ignoring the requirement, but we were trying to actively identify how to satisfy it, would be given the species that they said would satisfy the requirement. And then Ms. Wolf, who was very helpful, would note that they didn't satisfy it. And then in preparing to excavate the area to have the planting area that was contemplated in the EIDR that was conditionally approved, we were told by the landscapers that because of the location of it and because of the way that they move snow on the property, that it was going to be ripped up repeatedly over the course of the winter, and that we were stupid for thinking of putting it there and we should think of putting it in another place. And so we were basically figuring out where we could keep the planting area the same, put it in an area that may actually serve the drainage goals of this committee better, and went about and reaching out to the town to figure out how that could take place. We were told by Ms. Wolf that Nora and Mike would review a hypothetical location of where the planting could be. And then at that point, they would make a determination of whether we could do just an administrative EIDR to move that planting from basically the parking lot right next to where vehicles pull in, and hence a plow would pull in to clear snow, and would push snow around to the back of the property. We were told that after, they made that decision, that they'd inform us, and we made substantial progress long before the June 15 deadline back in May. We were advised in writing that the proposed modification, including the relocated planting area, could be handled through an administrative EIDR, so long as it remained the same size, and was conditioned on the same eastern native species of plantings. So we relied on that representation that was made in writing, went ahead, retained Norwood Engineering to go ahead and get a revised plan showing a new planting area, incurred additional expense related to that, prepared a revised plan, and submitted and paid the fee for an administrative EIDR, just so that we weren't going rogue and moving the planting area. This matter, unfortunately, went off the rails before then, before the June 15 planting deadline, when subsequent to submitting it, my father submitted a legal letter to the town, and in response to concerns about potential enforcement action regarding the ticking clock on the plantings. And in response from an official town email, Nora called his submission, his letter, a work of fiction and bluster, referred to him as indisposed, and said that she hoped him writing this letter helped him bide his time, while at times he was close to death in the hospital. In other words, Nora mocked my father's hospitalization while he was actually hospitalized. And what makes that especially troubling is was not simply an insulting email. It was not unrelated to the decision-making process. In that same communication and sequence, after being told that an administrative EIDR could be used to simply move a planting area from higher ground to lower ground, where logically the drainage is better, and following a position statement from the very respected Norwood Engineering, also outlining how it would actually be a de minimis change, was the language they used. Ms. Loughlin took a adverse position, and basically concerning the administrative EIDR that we had been previously told was unavailable. As a result, my father objected to Nora's continued involvement because of this personal hostility expressed with adverse government action in the same email, and raised questions about the impartiality of the process, and asking why we needed to appear before this body regarding that, when we were previously told in writing an administrative EIDR would be sufficient. Apologies that we're not here with our engineer today, for all of you, to resolve this matter. But unfortunately, he's not able to join tonight, and he just saw the email today that was forwarded over the weekend by outgoing or retiring town council, which was something that we learned since we've been in contact with Attorney Ahern concerning this matter, and he's been very respectful of my father's serious health conditions, including powerful chemotherapy-based drugs to boost his platelet count so that he can undergo a variety of surgical procedures. So I would respectfully request that the board hold off on taking any substantive action tonight. I did not share my comments lightly. I'm happy to have my father, when he's able, forward that email to any board members if you haven't already seen it, so that you're aware of it. I think it's something the town should be aware of. Certainly, when attorneys take a position at that point, maybe it should have just gone to town council before Miss Nora responded. But I'd ask you not to take any action tonight, and that hopefully whoever is taking over for Attorney Ahern, if he's not going to be working on this matter anymore, get in touch with my father so that we can get this back on the agenda when he's able to participate, and when we have sufficient time to make sure that Norwood Engineering can join. So thank you for letting me speak.
Thank you for coming to update us on your father's situation. And I am very sorry to hear of his health challenges, and I hope he starts to feel better soon. Nora, it sounds like, do we have to take any action as far, this is not a public hearing if we choose not to take this up at this time?
Right, so this is not a public hearing. As the board knows, this has been on multiple agendas going back to June 2nd. There have been multiple requests to delay it to the next meeting. The most recent one of those requests was for your July 14th meeting, which time Mr. Kring asked that it be continued to this August meeting. And Mr. Ahern, in communication with Mr. Kring, said that they would do that. So there have been multiple continuances. You can continue it as long as you want. The application was originally approved with conditions in October of 2025. Several of those conditions remain unmet.
Thank you. I think, given the applicant's request, sorry, Phil, yes.
I was just going to say, when does the applicant want, subject to his father's health, for the continuance to be? Because rather than just scheduling it for the next one, we should ask the applicant when to put it on the next agenda.
Excellent suggestion.
I appreciate that, and I appreciate the comments of you, Ms. Rawlings and Mr. Giordano. So My aim would be to get this resolved as quickly as possible. The items that are outstanding, from reading through the notes for tonight that were forwarded, and my father subsequently forwarded it to me a couple of hours ago. We thought that the lighting requirement had been met. We submitted the invoice from the electrician, and hadn't received any further communication about that. It was news to us that that's an outstanding item. We're happy to do whatever needs to be, done there to further resolve that. We'll need some guidance because we haven't gotten any communication about the lighting. Those are the two front light fixtures. The planting area just is what we need to contemplate. I Yeah, it's hard to know. He is out of the hospital now, and I'm hopeful that he can make a recovery. But at some point, I may need to get other counsel in conjunction with Nord Engineering, because I want to get the plantings done before October 15 or November 15, whatever that date is, and it's going to require a little time because DigSafe has to be notified, since there's a section of pavement that will be removed. And then I, of course, have to line up the contractor to do that and then have access to the species of plants. So I can't give you a definitive date just yet. I know Attorney Ahern and my father were communicating. It was also news to us that he had retired or was going into a new role. So we're not exactly clear, who at the town we should engage with about that. So I'll follow up with him on that. And maybe we could just table that and him and Attorney Ahern could speak. But I would hope September, because the board will have to make a decision, of course, and subsequently we'll have to get the plantings approved and purchased in time for November 15th. So I really don't want to get into October again, where when we got the conditional approval last October, the planting date was set from April to June because it was so late in the season already for planting. So I really want to get this wrapped up. These are not major issues by any stretch. But yeah, so I appreciate that, Mr. Giordano. That's a very long-winded answer to your question, but maybe I'll follow up with my dad tomorrow and make sure that him and Attorney Ahern figure out if Attorney Ahern is who he should still be engaging with.
So if we put it for the September meeting, a meeting in September, can you apprise the staff of
Absolutely.
7 to 10 days prior to such meeting as to whether or not your father's health would be
Absolutely.
adequate? Because then,
Absolutely.
because we don't want to fill an agenda and then find out that you can't attend or your father cannot attend. And obviously we're very sensitive to, the health conditions issue.
I appreciate that, and thank you for the sentiments, and absolutely, I'll plan to apprise the staff, and we'll go from there. But yeah, September, I think if you have 2 meetings in September, I would say the later one, just so that I make sure I have enough time to give Nord Engineering notices as well.
We can do that, and I think that makes sense. Just give us, if it's not going to work, I think just letting us know as much in advance makes sense. And also given the change in town council and the circumstances here, I think it would behoove this board to get advice from town council
Right.
before we continue to take up this matter as well. So I think giving it some time for us to engage on that level is helpful for us
Yeah.
as well.
Mr. Craig, there is new town council that's been already approved by the select board, so you should
Okay.
probably coordinate with the staff on whether or not, because Mr. Ahern is going to be passing the baton to the new town council.
I believe that transition has already occurred, and Attorney Ahern is occasionally in a consulting role, but the new town council is the responsible party at this point.
Yes, and Mr. Ahern has notified Mr. Kring first on January 21st, where they were engaged in an email conversation where Mr. Ahern noted that the application could be scheduled for the July 28th meeting or for a meeting in August. Mr. Kring said that he should be available in August, and on July 21st, Mr. Ahern notified Mr. Kring that the date of the discussion was scheduled for August 18th. Then Mr. Ahern notified Mr. Kring this weekend, reminded him of the August 18th meeting date, and also notified him that he would not be continuing. as town council. So this matter will be taken up by the town's representative at KP Law, and I have scheduled on your September 8th meeting agenda an executive session with KP Law to discuss this.
Okay.
Thank you. I think that will be
Thank you.
very helpful.
Yes.
Thank you.
And then we can schedule the matter for consideration on September 29th.
Excellent. That's the later meeting in the month. So that sounds like that
Yes.
kind of ticks all the boxes for this conversation this evening. Okay, well then it's not, as this is not a hearing, we don't have to make any motions. We don't really have to take any action. We can just table this matter and move on to the next agenda item.
Before you do table it, though, I think you should just make it clear that the outstanding conditions with the light fixtures are that they are not dark sky compliant light fixtures.
Thank you.
And with regard to the landscaping, the board has not approved an alternate location.
Right. Thank you. Yes, that's right, Mr. King. You did ask for some clarity there, and I had a note in my head to mention that. Yeah, the fixtures that are installed are not dark sky compliant. I'm not sure, the disconnect there, but they are not. They do not meet the dark sky compliant requirement. So I think that's the outstanding issue there is those fixtures, the fixtures in and of themselves aren't appropriate in that respect. And yes, I believe we have not taken any action on approving an alternate landscaping plan. So we would need to see that and discuss that and decide whether or not the board's amenable to approving an alternate location. It sounds like you're not looking to change species or potentially, but any changes to the landscaping plan, the plan would need to be submitted and the board would need to review and decide whether or not we want to approve the changes, any or all of them.
So you don't currently have an application that has been filed. There was an administrative EIDR application which was found ineligible. That application did call for a change in species as well as change in location. So what's needed is a modification application proposing exactly what the applicants are looking for.
And for the record, in writing, we specifically asked about moving the planting location based on the feedback from the contractor. And we were told to submit an administrative EIDR. And we then were told that it was being reviewed by Mike and Laura, Mike, the building commissioner. And then subsequently, we were told that it could be approved by an administrative EIDR in writing by Ms. Wolf. Went ahead, engaged Norwood Engineering to make that revised formal plan showing the proposed location we had submitted for initial consideration, and pay the application fee for an administrative EIDR simply to just move it from the front to the side rear of the property. So just that's important context for the board to have. There's no bad faith here when we're paying additional fees, hiring engineers, being told in writing this can be approved with an administrative EIDR. And had that been what happened, the plantings would have been in by June 15. So I thank you for your time and your words and understanding about my father's situation, Ms. Rawlings, Mr. Giordano, and others. And I look forward to taking this back up in September so we can put this issue to bed.
Thank you. So we will tentatively, we'll put that on the agenda for the 29th, unless we hear otherwise from the applicants. We will plan to take the matter itself up on the 29th, and we will have our executive session with council on September 8th. All right. Is that sufficient to address this matter this evening?
Thank you all.
Thank you.
Okay. Thank you.
There's nothing else we need to do on this matter at this time. We can just move on to the next agenda item.
Yes.
All right, then our next agenda item is continuation of the public hearing for consideration of amendments to various planning board rules and regulations, standards, guidelines, and meeting procedures continued from July 14th, 2026. And there's a whole list, but I believe the two that we are looking at are access approval overlay district rules and regulations, and I muted myself. My apologies. The bicycle. Sorry. So I will hand the floor back over to Nora.
Yes.
And Ariel. Sorry.
So as you know, we have a public hearing that's ongoing for all rules and regulations. The two that the board committed to review tonight were the access approval overlay district regulations and the bicycle regulations. Has everyone had a chance to review those?
Nora, is your microphone, it's very muted. I can barely hear you. I don't know.
It's on the maximum.
Okay,
Yeah.
all right.
I can hear her, Phil, pretty well.
Okay, I didn't know if maybe it's mine. That's fine.
All right, so has anyone had a chance to review the, why don't we start with the access approval regulations? Just to set the table for this, these regulations were never adopted previously. This is a new set of regulations. The access approval overlay district, I believe, was introduced in 2015. And in the bylaw, it says that the town will adopt rules and regulations, but the planning board never got around to it. So this is the first time that we're seeing these rules and regulations. And I can share them on my screen.
I had one question
Yes.
related to, I just saw the fees on there, and I'm just curious, given that this is a new new bylaws or new document, where did the fee, what's used as a threshold for as a starting point? Just out of curiosity, is this consistent with other kind of similar
It is.
similar within the town? Yeah.
Yes, I believe we look to the EIDR and special permit guidelines when we proposed a fee, but it's completely up to the board to decide
Yeah.
what they wish to choose. Having trouble sharing. Give me 1 minute. So the fee that is proposed in this draft
This is section 3. Okay.
is a $750 application fee for a project involving a structure. And actually, it looks like we put $750 for projects involving renovations or additions to structures. Then for an amendment of a previously granted approval, we have a fee of $500. And for a minor modification of a previously granted approval, we have $100. So those are similar to fees for EIDR and special permits. They're slightly less, I believe. EIDR and special permits for a new building are $1,000.
I was looking at mostly the inspection fee was the one that caught my eye, just because it was a bigger number.
Yeah, so we have inspection fees on our subdivision regulations, and we do not have inspection fees on our standard EIDR or special permit, because in those cases, the work is affecting the applicant's property. In this case, the work is affecting the public road.
Got it. Okay.
That's why these fees are proposed, and these fees are the same as the fees for inspectors.
Got it.
That are
Thank you.
Subdivision regulations.
Nora, could you just give us like a high level kind of summary as just the way you usually do scrolling through, just because I don't have questions. I think they're very well written, but I think it might help.
Right. So they track the zoning bylaw with the purpose and authority and the applicability. In this case, the access approval overlay district applies to certain sections of the town that are specified in the official zoning map. And right now it essentially deals with the area of Clapboardtree Street and Everett Street, where the Westwood land meets the Norwood land. It does the same thing on University Avenue and Canton and Dedham Street, where Westwood land meets Norwood and Canton land. And these regulations would apply if that zoning bylaw section was amended to include additional areas. Then there's a section about adopting and amending the rules. That's the same language that's taken from all your rules and regulations. Says it's effective upon signature by board members and filing with the town clerk. Definition of terms, they're the same terms as defined in the zoning bylaw. Then we have a section on application submittal and what the process is for submitting an electronic application through our application portal. We talk about preliminary staff consultation, which is a recommendation for this type of approval, that before an applicant go too far down the road, that they meet with staff and then meet with the land use committee to discuss their project. That's important here because projects that involve town roads should have discussion with representatives of the land use committee, including the police department and DPW. And then we also offer a planning board pre-application review for this type of approval. That's something we also offer for subdivisions. We don't generally offer for site plans or special permits. Application fees we already discussed. They track more or less in line with our similar applications.
Could I just ask about the pre-application language?
Yes.
I had one quick, if warranted by the complexity of the application, I'm just give us some guidance as to what is the complexity that might trigger this or may not.
So far, we've only had one application that was actually never officially filed. This bylaw was instituted at just before Benchmark was approved in Norwood on Clapboardtree Street. And there were discussions at that time because Benchmark was looking for a curb cut onto Clapboardtree Street, which was a Westwood Street. And the planning board was under consideration of this section of the bylaw. It had been advertised, it was going before the May town meeting, and they continued meeting with the applicant, who didn't actually file a formal application. And the way the bylaw was written, it became effective after the approval for Benchmark in Norwood took place. So it didn't actually apply to that. So we have yet to have an application that's filed under this section. So I don't really have anything to explain to you. Other than something like Benchmark, where it was a single driveway entering onto the town street, was not considered a complicated application. And that was not something that we would have required a pre-application conference for. If there's something that's more concerning, that maybe has multiple access points or that has a significant volume of traffic, the board might want to consider a pre-application conference to discuss it.
I also had a question on the last sentence, which said regarding the it's a mandatory advisory pre-application conference. The word shall on both of that and shall not be binding should that be might or may as compared to shall?
Well, I think the reason that it says shall is that it's trying to instruct an applicant that they cannot take any comments made by a planning board member at that pre-application review to infer that that planning board member will support the actual application for access approval overlay.
Oh, I see what you're, okay. I didn't quite get that. Okay.
So we're saying that it shall not be binding. Whatever the board members who engage in that pre-application, what their discussions are during the pre-application, do not in any way restrict their action.
So comments that might be initially supportive or whatnot shall not necessarily, impact a subsequent consideration.
Correct.
Okay.
The point of the pre-application review is just so that the board members who are on that subcommittee and the applicant can have a thorough discussion before the applicant produces final plans to submit for an application.
Okay. All right. I appreciate the explanation. Thank you.
All right. And then we discussed project fees. Peer review fees are standard. Whenever the board needs assistance of a peer review consultant, it's always at the applicant's expense. Inspection fees, we just discussed, have to do with the town engineer or the appointed consulting engineer having to review and inspect the roadway and driveway when it's eventually approved. Transcription costs, this is a section that's in all of our regulations. If the board wants, if an applicant wants a transcription, they are essentially responsible for the cost of obtaining a transcription. Delinquent fees have to do with whenever there's unpaid amounts on the peer review costs. We actually don't usually run into those because we require upfront deposits on all peer review. Application submittal requirements are essentially the same. For all applications, they're electronic. Request for waivers, this discusses how you can put a request for waivers, in which case the board can hear the application, but the application will not be considered complete unless those waivers are granted. Parties in interest and certified abutters list, that's standard in all sets of regulations. Butters are considered applicants with property within 300 feet of the subject property. The section regarding other variances, permits, and special permits says that where they are required, they also have to be obtained. That the planning board's approval does not substitute for those. And then there are the specific plan requirements, title block, stamping by a professional engineer, locus map. Those are all standard on all your applications as well. Same with existing condition plan requirements are standard. Site development plan requirements are standard. That's nothing unusual in this set. Plan profile, streets and ways, that's taken from the subdivision regulations. Architectural plans and elevations are taken, this language is taken from the EIDR and special permit regulations. Same with the landscape plan requirements, the exterior lighting plan requirements. Wireless facility plan requirements could be applicable. It's possible that there may be a wireless application that also needs an AAOD approval, so that those are just copied over here. Required reports, including a traffic report, narrative report, stormwater management report. Fill removal calculations, if that comes into play, that's taken from our earth material movement section. Explosive permit, that's a section just noting that if someone needs to do blasting, they need to apply to the fire department and receive approval from the chief. Restrictive documents, if there's a need to place a conservation or historic district restriction or any type of deed rider, those have to be produced and submitted along with the application. Same with subsidy agreements. And then there's a requirement for construction schedule, provision of security. So this is much like a subdivision review, that if they're going to be working on town roads, the planning board can require some type of surety to be placed either in the form of a bond or a tripartite agreement.
How is that determined as to whether or not surety might be required?
It's determined by the planning board. So if the planning board, if it, again, to use the example of Benchmark was simply constructing its own driveway through a curb cut onto an existing street. They were not altering the street at all, so there was no need for surety. In another instance, an applicant may be altering a town road to meet the needs of their project. If they had a project that was going to bring substantial traffic that required widening of a road or adding traffic signals, something along those lines, you would probably want surety to make sure that the project was completed properly at the applicant's
Is
expense.
there any de minimis or minor exceptions to those that it might be administrative?
It's always at the board's discussion, discretion. So no, there's not an administrative review here.
Okay.
Nothing in the access approval has administrative review.
Thanks.
There's another section about a site visit, which would probably be appropriate in the case of a significant project. There's this section on formal review, describes the process, how we refer to other boards and departments, how we hold public hearings, what are the rules of procedure for public hearings, very standard in all of your application sections. What happens when there's a change in the project or continuation, that explains how the hearing gets continued. Disposition of the application, this explains the vote. It would be a simple majority that's needed to grant an application, an access approval, overlay district approval. Talk about the decision. You have 90 days from the close of the public hearing to issue a decision. We typically issue them much more quickly than that. A notification decision goes to the town clerk. And then this next section says that the applicant would then have to obtain any necessary permits and approvals. There would, in most cases, be a curb cut approval and a street opening permit approval that would be needed. Constructive approval, this explains what happens if the board closes its hearing and fails to issue a decision within 90 days, then the project is constructively approved. As long as the applicant follows the state requirements for constructive approval, which require notification to the town clerk within 14 days of the expiration of that 90-day period. There's a section that discusses how an applicant withdraws their application. Appeals are also addressed according to section 10.1 of the zoning bylaw. There's a section on repetitive applications. This also is consistent in other sections of your rules and regulations. If an applicant wishes to file the same application that was previously denied within 2 years, they can only do that if the board votes to allow them to do that. There's a section on the effective date of the approval, and that's the date that the approval is actually recorded at the town clerk. So another section, lapse of approval. The access approval decision is valid for 2 years from the date of issuance. And an extension of approval, the town can grant extensions up to 1 year at a time for good cause. Modification, amendment, or renewal of an application, that explains what we have in all of our decisions, that if it's a de minimis change, it can be approved by the building commissioner. If it's a minor modification, the board can consider it a regular meeting. And if it's a significant change, it has to be a new public hearing. Evidence of satisfactory performance. This just goes through how we determine that the project has been built in accordance with the approval. An inspection process explains the specific inspection requirements when there are changes to the public roadway. Severability of provisions, that's a standard section in all of your rules and regulations, and same with waiver of full compliance. So it's sort of an amalgamation of your subdivision regulations, EIDR regulations, and special permit regulations.
Could you just, one last question, because I thought they were just coordinated very well. 14, I think it was 14.09. There's a supermajority provision.
Let's see that.
49, no. Maybe 8. There's a supermajority of 4 votes. And then
For repetitive applications, yes. So that's if someone comes to you and applies for access approval overlay district approval and you deny it and they wish to come back with the same exact project, no changes within a 2-year period, the board does not have to hear that application unless a supermajority of the board votes to hear it.
so that would preclude a quorum of 3 from
It would.
acting.
Well, this would be to allow the repetitive application. So you would need a supermajority to allow a repetitive application within 2 years. But then when the application is allowed, you would only need the simple majority to approve it.
Okay. Okay, that was my question. Nothing else. I thought it was very well done.
Thank you.
Thank you, Phil. Anybody else have anything to add to this from the board? I appreciate the time put into this. I think it's really helpful to have the rules and regs to complement the bylaw. So I'm really, thank you for getting that done.
No, it was very well structured. I really liked it.
Thank you.
I think if no one objects, I'll take public comment on each rule and reg in success before we move on to the bicycles, just because they're kind of disparate. So, so at this time, I will open up the floor to public comment on the access overlay district rules and regs. If anyone would like to comment, please raise your hand and we can enable you to speak, or use the Q&A feature in the Zoom app. We would just need your full name and address.
Except there's no one in the public attendees.
No attendees.
Oh, yes, that's actually, I know sometimes people ask how many people are on the Zoom. We currently have no members of the public in our attendees list.
Can I leave the board and go into the public?
Do you want to ask a question?
I'll recuse myself.
All right, I think it's we have not seen any public comments, so I think it's fine to move on to the bicycle parking regulations and whatnot.
Okay, so the bicycle parking regulations really have not changed, other than the, I think the only change had to do with the formatting. I don't believe there's any change in language here. I think these are identical to your previous one. I know the images are the same. I don't see anything that's changed. I know that Maureen had a comment on one of the image titles. Let me just see what it is. Sorry to make everyone dizzy going back and forth. No, I think that might have been in another set of regulations. I don't see that. I don't see anything that needs to change here.
I have one question on this. and I tried to what makes for my own benefit, what makes a rack a bicycle rack acceptable or unacceptable. And I'm gauging based on the design standards section that it's the needs to secure the entire bike, not just the wheel. Is that the primary driver of what
It
makes
has-
it acceptable or not?
It has to secure the bicycle at 2 points.
Okay.
And it cannot, and prevent the bicycle from tipping over. And the reason why the 3 designs, the inverted U, the post and loop, and the circular type are allowed, and these are disallowed types of bike racks, is that they do not, the way people actually use these lower types, they put their bicycles across what is intended to be multiple bicycle sections.
Oh, to take up more spot. Okay. Got it.
Yes, yes. So they're not effective. It's not that
Got
they're
it. Okay.
faulty.
I was
they're-
wondering why. Yeah, that makes sense.
So the top ones meet the design criteria to allow you to secure your bicycle at 2 points without it tipping over. And they are effective and efficient.
Got it. No comments for me. I was just curious. I've always wondered that.
Yeah, I had no comments. It looks fine to me.
Meg?
Looks great.
Yeah, I had nothing to add. As you say, they really didn't change and they
Right.
seem to be working just fine. So,
Exactly.
I've gotten the Steve Olenoff speech on these, so I know all about the bike racks.
you've gotten the whole history and yes. All right. Then at this time, since it doesn't seem like there's any further board member discussion, I will open up the floor to public comment on the bicycle parking design guidelines. If anyone would like to offer comment or ask a question, raise your hand or use the Q&A, full name and address, please. Again, there's nobody, but yeah. So given that there's nobody here to offer comment, we had opened the floor, but I think it's appropriate. Oh, before we take the motion, we should, or do we want to choose 2 for the next meeting, or is our next agenda pretty heavy
So
duty?
I think your next agenda, because you're going to have executive session at your next agenda and then go into a special permit hearing. Remember the 260 Washington Street permit was continued to September 8th. And I believe there's another application pending for that one as well. I'd recommend that you wait until September 29th to consider additional regulations, but you can certainly pick the 2 that you wish to consider next.
I think that makes good sense so that we will have them to put on the agenda so that we can be prepared to review them on the 29th so that we keep the momentum going unless anyone objects.
No, that makes sense.
Yep.
Excellent.
Agreed.
All right, then, what would folks like to take on next out of the remaining? Could we just get a quick list of the ones that are remaining just for
Yes.
possible?
You have the earth material movement approval, rules and regulations, solar design review approval, rules and regulations, University Avenue mixed use district rules and regulations, and regulations governing the subdivision of land. Then you will also have sidewalk driveway transition standards to consider, but I don't believe Elijah actually drafted those before he left. So those still require drafting. So I'd recommend you either tackle earth material movement and solar design review, or either of those and University Avenue mixed use district regulations. I'd recommend you take subdivision regulations on its own. That's a very lengthy set of regulations. And although we did not make substantive changes, you may want more time just to discuss that.
Yeah.
Yeah, let's keep working down the list.
Yeah, I agree with Nora's suggestion.
Okay, so earth material and solar,
Yeah.
For the
Great.
September 29th.
29. Great. Excellent. All right.
Moving along, that's good. We're
Yes.
getting through them
I like that. I think this approach of doing it in chunks has been really productive. So I
completely.
for
It
doing
just
that.
makes it manageable.
Right. It's not overwhelming saying we have all these, right? Because as we've alluded to, I would say like both the university station, that's a big one, and the subdivision of land, that's huge. So trying to do those in addition to everything else, I think was stalling our progress. So this has been very productive and I fully endorse continuing on this way. Okay, so we have the two for the September 29th meeting. So sorry, I didn't mean to stall us out there, but I wanted to take care of that item of business before we moved on with our motions.
Tim, you're up.
All right.
Keep on your toes.
Yeah. I move that the planning board adopt the following sets of rules, regulations, standards, and guidelines as revised at the August 18th, 2026 public hearing session. Access approval overlay district rules and regulations, bicycle parking design standards.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Mike?
Aye.
Tim?
Aye.
Bill?
Aye.
Vote aye as well. That motion carries.
Motion
Tim, you're still up.
I move that the planning board continue the public hearing for amendments to various planning board rules and regulations, standards, guidelines, and meeting procedures to the planning board meeting, which will be held via Zoom on Tuesday, September 29th, 2026 at 7 p.m., where a Zoom link and associated call-in numbers will be provided on the town's calendar on the homepage at http://www.townhall.westwood.ma.us.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Tim?
Aye.
Mike?
Aye.
Bill?
Aye.
I vote aye as well. That motion carries and that public hearing is continued. All right. Thank you all. Our next agenda item is initial discussion of potential planning board warrant articles. I'm actually very excited about this one. So Nora, the floor is yours.
So this is around the time that the board usually starts thinking about what articles it wants to consider for the upcoming town meeting. This year we actually have two town meetings. We have a town meeting in the fall, or we think we will have a town meeting in the fall. The select board have not officially voted to open the warrant for that, but I expect them to do so at their September meeting. They are unlikely to consider any zoning amendments at that town meeting. That town meeting is intended to address the fire station issues. But there will be a regular town meeting in May of 2027, which will be open for the planning board's typical zoning amendment articles. So I think the board should discuss what type of articles they want to consider so that we can come back at your September 8th meeting for a more robust discussion. And we can prepare legal notice so we can advertise for those hearings. Hearings are needed before, just planning board alone hearings are needed before an article can go to town meeting. But after the planning board has its initial public hearings, as you'll recall from past years, you then go to public hearings with the Finance and Warrant Commission before you go to town meeting. So it's a fairly lengthy process. We typically open the public hearing session for a spring town meeting in January. When you have a fall town meeting, it's open much sooner than that. So while I don't think it's likely that you'd have an article on the fall town meeting, if that's something that you want to request of the select board, you can do that. In that case, we'd have to move very quickly to have time to hold a public hearing, but in front of the planning board, and a public hearing in front of the Finance and Warrant Commission.
We even have time for the fall.
Still time to do that.
I mean, even considering something now, do we, on such a compressed schedule, could we even possibly do it for the fall?
So it would be very difficult. I also think that the select board just is unlikely to accept warrant articles for that town meeting, which it seems to have a single purpose. But if it is something that the board feels strongly about and they want to ask for that, I would work with you to draft what you need and request a warrant article from the select board. I don't recommend that you do that, but it may still be possible. It would be difficult. I don't know the Finance and Warrant Commission's meeting schedule for their public hearing for articles to be considered at an October town meeting, but I believe it's very tight. Remember, it takes about a month to advertise. So if we advertised a hearing now, that hearing, the soonest that could take place is at your September 29th meeting. And you would have to have your own public hearing before you could go to the Finance and Warrant Commission for their public hearing. And I don't know when their public hearing is scheduled yet.
And after there, it just seems like it's such a compressed schedule. I can't imagine how we could get it done.
I think it would be
Yeah.
difficult, and I think there's the
I was
question
gonna,
of what
Nora, can I
is
ask
allowed.
for the Deerfield project, do they need any zoning changes to do whatever they have on the potential plans that may come up? Is there, yeah, just,
So if they do, we won't know until that project is designed. So they first, they would first need town meeting approval to spend the funds to design the project. So that's the first step. That's what they're asking for. Funds to design it and to construct it. It's only after the design is produced that we'll know if zoning amendments are needed. I don't think there's any intention at this time to request a zoning amendment. There may be zoning variances that are needed. So let me step back. The use is an allowed use at the Deerfield site that they've selected to go forward with their design. So a municipal public safety facility is an allowed use at that district. We don't know yet whether they'll need a zoning variance or a special permit for any portion of that design. That's to be determined. It's possible that they could, if they found that they would need something, it's possible they could request a zoning amendment so that they wouldn't need it. I don't think that's likely in this case. And if it did happen, it would not happen at the October meeting. It would happen at a future meeting.
So just in terms of timeline and anticipated, because we had talked about this at the last meeting, the expectation is to just get to do the approval on funding this fall.
Correct.
Then we go through, then we're going to be doing essentially the bulk of the work thereafter, which would
Yes, you will consider. So if town meeting at the end of October supports an application, supports funding for a new fire station at the Deerfield location, and if the vote in November supports the same, then the project will be designed, and in the design process, they will come to the planning board to discuss the proposal and to request EIDR approval for the proposal.
Yeah.
That will probably be sometime in the spring. I expect there will be a pre-application meeting with the board to discuss the project before then, but the actual application would be when they're in the design process in the spring.
Okay.
Thank you. So again, I typically don't go first, but since I have this burning desire to bring something up, I'm going to. The one warrant article that is kind of rattling around in my brain that I would like the board to consider pursuing, it's kind of a nice segue from the rules and regs, is some expansion of the access overlay district, both in scope and in areas. I'm interested in seeing that applied to areas like Purwall Street and potentially any other areas that may not be covered by it already, that are kind of on our edges that border neighboring towns. And while it only applies to a curb cut now, I think there might be ways for us to look at expanding it to give us a little bit more oversight over our roads that are potentially being considered as access points for projects in other towns. And I personally am interested in trying to put see if there's an appetite both from the boards and from the town to do something in the fall. I'm not sure whether or not the select board and or FinCom would be amenable, but given kind of the specter of Costco, and this is something that I think could help the town of Westwood with that situation, I'm feeling a little radical and I'm interested in trying to see if we could do something for the fall, but if not, definitely for the Springtown meeting, if the board is interested in taking up something along those lines.
I love the idea. I don't know if the timing will be able to do it for the fall, in all honesty. It's not just a small bite, it's a bit of a bigger bite, and there's gonna be enough on the town's plate, essentially, I think. But I'll open to other suggestions.
I would say, Ellen, if it's, I don't know the specifics you have in mind, but if it's something to protect the town, I would be interested in, exploring a potential fast track. But I don't know what you're thinking,
That's very much what I'm thinking. It's the challenge, just using Costco as the example, because it's kind of the most pertinent, is it's a project that we have no oversight because it's not a Westwood project, yet it's right on our border, and there will be impacts to the town of Westwood, and particularly those neighborhoods that will abut that project that are Westwood neighborhoods. But their ingress and egress is meant to be, it's a Westwood road. So that might be the way that, and we do have this access overlay district that exists in areas that are kind of on these liminal spaces where like we saw with the benchmark in Norwood, that it offers us the opportunity to come to the table and advocate for our community in a way that currently we can't with something like the Costco, or we don't really have any leverage. I don't know if that's the right word, but yes, I am thinking of it as something that could protect the town. I know Costco's not really moving forward right now, but I'm not sure when they intend to. So for me, it's something of not dire urgency, but something I would like to try and address soon if there's an appetite for it amongst all of us and other boards that need to be involved in those conversations. I think it could be a benefit to the community, but also to some of the other conversations around some of the other projects. I feel like I have heard that there are residents that don't feel that the town government is responsive enough to their concerns. And I feel like this is a way for us to try and be responsive to a very real concern that's affecting a bunch of neighborhoods over there. So that's why I'm kind of interested in, and it's a concern I think we all share. So that's why I'm kind of interested in if there's a way to do something sooner rather than later. I think it's worth looking at it. Again, just my opinion. And obviously we could say we want to do this and the select board could say we really don't want to add anything else to the warrant. And that's fine. Spring, I think, is still, Nora had mentioned that anything we do, it's backdated to the date that we advertise it. So if we can't make it happen for a fall town meeting, I think if we start advertising it now, we are achieving some of that retroactive coverage that I think I'm interested in making sure we get something sooner rather than later. But these are just my thoughts. I'm very interested in what y'all think.
I love the thought. Nora, how difficult, this is not a small potatoes kind of drafting project.
So the first step would be conferring with our new legal counsel, and have her review the section of our bylaw we have now and consider what amendments might be appropriate. So we could work on that. We can advertise it, but we need to have a draft article filed with the town clerk's office on the day that the legal advertisement runs. In order to have the hearing at your September 29th meeting, we would have to have the advertisement run the first week of September. So we would need to have the first draft of the article written and recorded by the first week in September. That will be a challenge.
Nora, can it be pretty rough though? Just remind me how, like rarely rough outline, but hits the subject matter,
So for the advertisement in the newspaper, it can just be a title that describes what it is you're looking to do. This is the section you're amending, but then you have to refer interested parties to the actual language that's proposed as the starting article for discussion at the public hearing. So we would need that the first week in September, and then the public hearing would be September 29th. And then you would have to make your decision in that single public hearing that you had an article ready to move forward to the FinCom, who would likely be meeting the first week in October, and would likely be having a single public hearing, not a double public hearing like they have for the spring town meeting. So there just wouldn't be a whole lot of time to consider it. So we would work on drafting something. We would have it produced by the first week in September, and then you would have to review it individually and then discuss at your board meeting, September 29th, come to a conclusion at that single board meeting, produce it for any changes you're looking to make, take public comment, and then go to your FinCom hearing at the next meeting. In the meantime, we would have to get the select board's consent to put the article on the warrant. I would think they would need to do that at their first meeting in September. So
I was just going to say that we would probably have to, in order to do this, so that basically gives 2 weeks at most to create the draft. We'd have to probably get the select board in their first September meeting to sign off in order to go forward on the 29th.
Correct, and I think it's really 1 week because I don't think I'll have the ear of our town council until I return
Yeah.
in early September. So I think we really will just have 1 week
Okay.
to produce it.
Very,
I think the timing is extremely
yeah.
challenging. But there's no reason that we couldn't have it advertised for the next month's meeting and start your public hearing on zoning articles early. Even though it's for the May town meeting, you don't need to wait until January to open your public hearing. You can open your public hearing anytime you wish and just keep it active.
I'm also skeptical as to whether or not the select board would sign off. I think that's an issue.
I think the select board is looking to keep the October
Single focus.
till October town meeting focused on the fire
Exactly. And we could create a small distraction by trying to put something else on it.
station.
So,
I thought maybe it would actually help, but I mean, that's really something that they would need to weigh in on, and whether or not they think this would be something that would be a benefit to that meeting, or it would be better to defer it to the Springtown meeting. But they're not here, so we can't ask them.
Yeah, I don't know how complicated, what could we do to achieve the immediate objective to, you know,
Yeah.
from that? Is it, you know, we don't have to do everything we want to do at once. If we can achieve the immediate objective in a simpler way. I don't know what the language or what this looks like. So you know, Ellen definitely has more information on how this works. So.
Ellen, we could talk about it later too, but I also wonder, well, I think I agree with the intent of trying to protect Westwood. It's a little bit of a double-edged sword because you're kind of opening yourself up to introducing that to other neighboring towns to just take similar action against, you know, we could find ourselves then in a couple of years, right, and facing the same constraints for something that we might think is beneficial to our town. So I think it's a little bit of a double-edged sword. I'm interested in exploring what we could do more, but I tend to think the timeline is challenging for the fall too.
Yeah.
And that's a good question. Do we know if any of our neighbors have similar zoning?
I have not seen anyone enact a section of the zoning bylaws similar to our access approval overlay district.
Okay. But that's been there for a bit, and like Norwood has already come up against it with the benchmark, right? Like that.
Yeah, so we adopted it in 2015, was written in a way that it didn't apply to benchmark. And then, although the Amazon development was within the overlay district, it did not require a curb cut with access to a Westwood road, so it didn't apply.
I don't
And
see
right
the-
now, it only applies to curb cuts, not just using the road, right? So
Correct.
that would be something if we wanted it to apply beyond just when someone's looking to add a curb cut. Like if we had wanted it to apply to Amazon, we would have to make some edits to that part of the bylaw.
Yes.
Which I don't think it's not as simple as just adding a couple more streets into the current bylaw. There's more work.
Yeah, and it does require town council review so we can determine what you're actually permitted to do. So, you know, you can't usurp another town's authority in granting its own site plan review. You can only address the concerns that are pertinent to your town.
Nora, correct me if I'm wrong. If we advertise, doesn't that just remind me exactly how the retro date works? Because that actually might be a benefit even if we don't try to get to a fall meeting.
Right.
Correct. So what we do is when we advertise a zoning article, we act as if it has been adopted and approved by the Attorney General from the date we advertise it. And we can't issue any approvals that are contrary to whatever that zoning article says until such time as it's either defeated at town meeting or disapproved by the Attorney General. So we have this limbo period from the time an advertisement runs until we have final execution of the article.
But in
During that period, we cannot issue any approvals that are contrary. Now, there's a question of whether an abutting town can issue approvals and just ignore it. That is possible, but then if it becomes effective and there's an application pending that has not yet been approved, then we would.
You're reading my
require
mind.
the
If
application.
so, if we advertise now or effectively now, that puts us at the earlier date, which gives us the creation of the limbo period as broad as possible, which could be beneficial. Is that fair to say?
I believe it is, yes.
But when
So it
blank-
may be in our interest to advertise for it and then without necessarily seeking to get the fall meeting for consideration, but in order for us to get the process going and have that earliest date. Am I correct on the process, Nora?
Correct. Yes.
So I open it to the others just for consideration. I think that might be a good, effective way for us to get this essentially obviously not a protection, but a enhancement of our positioning.
Yeah, isn't that was kind of what Nora was hinting at too, even if it's in a spring timeline, just going early. I
Go
like that
early
approach.
and we
Yeah.
go to spring.
Right. I feel like we don't lose anything doing that. If we end up moving forward with something and it passes town meeting and it passes the AG, we've built in that retroactive
Exactly.
application. And if we end up
Exactly.
choosing not to move forward or move forward differently or whatever, it gives us some options. So I don't see us losing anything by taking that approach.
I actually think it enhances us, and I like the idea to get a good solid advertisement out there sooner rather than later.
All right, well, then I will work on that with our new town council.
Okay, good.
Thank you, Nora.
Thank you,
So
Nora.
then, while you have this subject open, board members should be thinking about any other zoning amendment warrant articles that they wish to propose for the May 27 town meeting.
Okay.
I love this conversation because it's always fun to hear what you all are thinking or what you're hearing from our residents that they're interested in. So
I can tell you one thing I'm interested in is looking at our zoning districts and our commercial zoning districts and our mixed use zoning districts and making sure that they are not unduly susceptible to new state law that was passed as part of the budget article and pending legislation that watered down commercial districts in a way that allows residential use through a variance in a commercial district. So that's something that all towns are now facing, and it's something that Westwood, which has only 6% of its land zoned for commercial uses, and which employs a split tax rate that really relies on the revenue from those commercial uses, that's something concerning to me. So I would like to propose, as of yet undefined zoning amendments intended to maintain commercial uses in commercial districts.
Nora, could you, I read about that, but can you summarize again because I saw about that's going to impact the town's.
Yeah, so
ability.
there are several there are several pieces of legislation, but the one that's effective already are changes to the budget bill that allow variances to be issued with lesser requirements, so that the standard uniqueness factor of soil topography and lot shape are no longer the effective test for a zoning board to determine if a variance is appropriate or not. They've changed the test requirement, and they've allowed variances even in towns that do not permit use variances. Westwood is one of those towns. You can't have a use variance, you can only have a dimensional variance, but the budget bill law allows a zoning board to grant a variance allowing residential use in a non-residential property. So that is what's concerning. So if you picture, just pull out any fully commercial or industrial property in Westwood, if the applicant, if the property owner wished to sell it to someone or redevelop it for residential use, they could do so with a zoning variance.
Okay.
yeah, I echo
There
you
are
on that.
other pending pending laws, pending articles being considered that could make other changes as well.
Okay.
No, Nor, I support that because that could have a direct impact on our budgeting, our split tax rate, our revenue stream. So I think I'm supportive of looking at what we can do on our end to kind of shore that up. I think that's important.
And it's not clear yet what we can do or how effective we can be, but I would like to request that the board tackle that, and we'll work with town council to see what we can do to put ourselves in the best position.
Yeah, I would be supportive of that. I'd love to participate and assist.
So we have a couple that I think we are thinking about already, but yeah. So Nora, when do you kind of need a list from folks about things that I know we always go through, we come up with a big list and then we narrow it down to, a digestible or achievable set of things. So
It would be helpful to have it for another discussion at your meeting on September 8th, and I will shoot to advertise warrant articles immediately after that.
Great.
That hearing.
Great.
Okay.
So does anyone else have anything they'd like to, on a high level throw out this evening, or just come back at our next meeting with?
I think come back to it. I think we need to also have Maureen in the discussion.
Agreed. I look forward to her input and her ideas on things we can do for the next warrant article cycle. All right. Well, thanks all. That was I do love those conversations. And Nora, thank you. I appreciate so that writing the advertisement or getting the language together and talking to town council, that's not nearly as Herculean task for you guys as if we were trying to come forward with a full article for the fall, right?
Well, it's for the advertisement similar. So the advertisement is just a description of what it is you want to do. But much like if we were going forward with the fall, by the time that hearing notice runs, we really do have to have the first draft of the language.
Okay.
With a longer public hearing, you have time to amend that draft, and you can amend it repeatedly until you get to what you want. So I'm less concerned about being precise in the article language when we have a longer public hearing to amend it.
Got it. Thank you. Great. All right. Well, if nobody has anything else on that item, I'll move on to our next agenda item. Sorry, but I switched my focus. I'm not seeing anyone wanting to continue with that. And this was just a discussion, so there's nothing to continue. Okay. Then our next agenda item is the review of draft meeting minutes from July 28th, 2026. Did everyone get a chance to review the minutes? And did anyone have any edits to propose?
No edits.
And does anyone need to abstain from this vote? No, we had everybody last time, right?
I was.
Mike,
No, Mike was out.
Mike was out.
yeah, Mike was
Okay.
not there.
All right, so I will be expecting an abstention on that one. All right, did anyone have any edits or addendums to the minutes?
No comment.
Not for me.
All right, then I would accept a motion.
I move that the planning board approve the minutes for the meeting of July 28, 2026 as drafted.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Phil?
Aye.
Tim?
Aye.
Mike?
I abstain.
And I vote aye, so that motion carries. Thank you. The minutes are accepted. Thank you, Jess, as always. Our next agenda item is updates from agency and committee representatives. Has anyone attended any meetings that they would like to share their liaison reports on?
No.
Same. We have long-range financial planning next week, so I'm sure Nora and I will have something to share at our subsequent meeting, but as of now, it's summer. It's been kind of quiet.
Yeah.
All right, well, that was easy. So our next agenda item is general miscellaneous updates and administrative items. Nora, Ariel, do you have anything for us?
I have one A&R plan that's still waiting. Mike, I think you just need a signature, and I feel terrible because the day you signed the last one is the day I dropped off this latest
Wasn't going to
one.
say anything, but I was going.
I will be there. I will be there tomorrow. It'll be done tomorrow.
Okay, appreciate that. And then trying to think, did we have a public hearing at the last meeting? Yes, actually, this probably comes into play here, so I didn't really look at this, but we needed an affidavit that you watched the last hearing in order to vote on Walmart Sparks application. I just noticed that
Oh,
public hearing was
okay.
last time, so
Yeah,
I think what I would ask you to do, if you did not already watch that,
yeah,
I doubt you had time to, I think I would ask the board to reconsider its vote. You closed your hearing, but you can still reconsider the vote, take a new vote on the previous motion, and Mike can abstain from voting.
Gotcha.
That
Okay.
works.
Um,
So
yeah,
do we have to move to reopen?
You would not to reopen the hearing, you would you would move to reconsider your vote on the application that came out of that hearing.
I move to
Move to
reconsider.
reconsider the vote.
Okay, I second Tim's motion.
Okay.
so I'll take roll call to reconsider the vote, and then just so I understand, we vote on that motion and then we actually take a vote on the application again?
Yes, so you
Yeah.
say
Okay.
on the original motion for the application for the Walmart Spark store at 2125 Southwest Park, there are no changes to the motion. You're just revoting it so that Mike can abstain, because it just came to our attention that Mike missed the first hearing session and has not prepared a Mullen Rule affidavit.
So we have to vote on the reconsideration, then the revote on this.
Yes,
Okay.
you do.
Substantive
Yes.
revote. Okay.
Take a roll call on the reconsideration. If that passes, then you take you need a new motion.
On the application. Okay, so currently I have a motion and a second on reconsideration. Is there any further discussion on reconsideration? Seeing none, I will take roll call. Tim,
Aye.
Phil,
Aye.
does Mike needs to vote on reconsideration because he's present, right?
Yes.
Okay. Mike?
I'll vote aye.
And I vote aye as well. All right, that motion carries. So now we are reconsidering. So now I need
And we need to
another.
but we need to reread the motion though, don't we?
So here's what I would recommend. I would recommend you vote to waive reading of the motion and then vote, and assuming that is seconded, you could make it actually a single motion, to waive reading of the original motion, to adopt the same motion and take a new roll call vote on the motion that was adopted earlier this evening.
I hereby move to waive the reading of the motion and to adopt the identical motion in a new vote.
Second.
All right, I have a motion and a second. Any further discussion? Seeing none, I will take roll call. Mike?
I abstain.
Tim?
Aye.
Phil?
Aye.
And I vote aye as well. So that motion carries. So now we've concluded that business.
That's all done, and you'd already closed the public hearing, so it doesn't affect that. So you're
Marvelous.
good. Thank you. I'm glad we noticed that.
Okay.
Yes.
I just want to make sure, Jess, you get your minutes right this time.
I do have a question, Madam
Yes.
Chair. So should I go back into the up there, or should I keep all this motion down here in the general miscellaneous?
Down in general miscellaneous.
All right, thank you.
Thank you. Good question. All right. Any other miscellaneous or administrative updates from our staff? All right.
Other than just officially welcoming
Yes.
Ariel Sasser, our new town planner. She started on August 10th. And she will not be here for your next meeting.
Oh, you're blowing us off already? You showed up once? What kind of town planner is this?
She will
Smart
be here.
one.
Wow. You know, we're going to be there. Ariel, it'd be nice to see a little commitment here.
Blame it on my in-laws, okay?
Oh, there you
We'll
go.
take the fall. We're going away for Labor Day, but
We're in by Zoom. You can
yeah.
go. You can still join us.
Okay, I said too much.
Well,
You
hopefully
might want to get away from the in-laws.
you'll be refreshed and all restored for our September 29th meeting.
There you go.
Perfect.
Yes, welcome. Very happy to have you
Thank you.
aboard. And we can be a little cheeky, but we enjoy our work. So welcome to the team. Thank you.
Exactly.
Yeah, thank you so much. I'm excited to work with you guys. I'm excited to join the Westwood team, and I've been here for a little over a week, and it's already been busy. So I'm excited to move forward. So thank you for the intro.
Thank you. And welcome. Yeah, any other administrative updates? I think that was the big one, right?
That was it.
All right, then our final agenda item is just to note our upcoming board meetings. We have a meeting on September 8th, 2026, September 29th, 2026, and October 13th, 2026. We are headed full steam into the Burr months. That's a little disconcerting that year is just zooming on by. But so those are our next 3 meetings, and that takes us well towards the end of the year. So with that, unless anyone has anything else that needs to be discussed this evening, I would entertain a motion to adjourn.
I move to adjourn.
Second.
I have a motion and a second and a third. Any further discussion on adjournment? Seeing none, I'll take roll call. Mike,
Aye.
Bill,
Aye.
Tim,
Aye.
I vote aye as well. We are adjourned. Thank you, everyone.
Have a good
Thank
night,
you all.
everybody.
Thank you.
Enjoy the rest
Thanks,
of your day.
everyone.